They say that the applicant was found in possession of multiple firearms, large quantities of ammunition, and explosive device, which is prohibited by law. These firearms, Your Worship, that were found at my client's house, it is not alleged these are unlawful firearms. My client has the permit to hold those firearms, and the contention that it is unlawful to have 7 firearms, it does not have merit, Your Worship. It is not merited. As I've indicated, that my client is disputing that he was found in possession of stun grenade, and the court will note in the photo album that you have been provided by the state, from the pictures that appear to have been complied by Warrant Officer Sgt Nkosi, there is no picture of a hand grenade in all these pictures, from picture 229 to picture 274 of the pictures. There is no picture of the hand grenade, and the accused is disputing that. I know, Your Worship, I'm not here to go to the merits of the matter. However, if you look at these pictures, Your Worship, there is no indication of the date. When were they taken? What time were these pictures taken? But what is contained is that these pictures were taken by this Warrant Officer Sgt Nkosi, but there is no date when was these pictures taken and at what time. And Your Worship, when you look at this exhibit B, there is no information of such particulars. And one will look at those pictures, Your Worship. You will take the pictures that have been taken from the motor vehicle. You look at the pictures that were taken where what looks like a mattress or a bed. There's no time when these are taken. And in a response that this court had to stand this matter down for almost 2 hours, the state indicated that they wanted to deal with the issues that have been raised by the applicant. And in doing such, Your Worship, there is no indication as to the time. But I want to move on, Your Worship, to paragraph 16.2, that there's a likelihood of evading the trial, section 60, 4B. He says that the seriousness of the offense might lead to him evading this trial. Your Worship, because of seriousness of the offense. In terms of Firearm Control Act, the sentence for contravening section 128A is 5 years, Your Worship. And taking into account of the 5 years, it's 2.5 years taking to the issue of parole in South Africa, Your Worship. And in this paragraph 6.2, there is nothing that has been given by the state that the applicant will evade his trial if he is released on bail, besides this issue of a lengthy trial. The applicant has indicated that he's got a house that is valued at 1,500,000. He's got a kid and a wife that is employed with this jurisdiction of the court. Why will then the applicant evade the trial if the applicant is emotionally tight and there's family ties within this court's area of jurisdiction? In paragraph 16.3, they are alleging that he might interfere with the witnesses and also the evidence. They are basing this on section 64C. Your Worship, there is no merit in this contention for the following reasons, Your Worship. My client has been suspended from his place of employment. He does not have access to any systems that are used by the police. And the state is alleging that he might influence the investigation and he might be working with other people within South African police services. And there's no evidence that has been presented by the state that Mr. Nkosi is working with other people from the within the subs, Your Worship. And this notion that the Mr. Nkosi will tamper with the evidence in paragraph 6.4 is not substantiated, Your Worship, because what you have to look at, Your Worship, is whether a police officer that is suspended does not have access to his work. Can he be able to interfere with what is happening within the police? And it is my answer, Your Worship, that no, Your Worship, there is no evidence that there would be interference. The people who were at his house on the 2nd of April are the members of the National Task Force. And those are the people that will have to testify in regard to what they say they saw there. And it is my submission, Your Worship, that these are police officers of National Task Force. There's no evidence that my client may be able to influence those witnesses, Your Worship. In paragraph 16.5, they are alleging that he might undermine the criminal justice system, and they rely on section 64D. This is the first time that this accused is arrested, Your Worship. And I will understand that if they say that Mr. Nkosi was once released on bail and now he's back before this court again, that will amount to undermining the criminal justice system, Your Worship, or the bail system. And as the facts stand before you, Your Worship, there is no evidence that Mr. Nkosi will undermine the public justice system. And they also state this, Your Worship, in paragraph 16.6, that the applicant is entrusted with enforcing the law, Your Worship. And it is common cause, Your Worship, that whether you're a police officer or an advocate or a magistrate, one day there might be circumstances that may lead to your arrest, whether wrongful or rightfully. But we cannot say because you are a magistrate, you are responsible for enforcing the law, you are not entitled to be released on bail. Because, Your Worship, what you must consider is that these are still allegations that still need to be tested before the trial court, and the trial court will have to make determination on the evidence that is presented before it. And it is not for this court to go in detail in what the evidence of the state, whether the state's case is wrong or not. And if you look at section 64A to E, Your Worship, it is clear what you have to consider in order to grant or refuse the bail. And it is my contention, Your Worship, that based on the facts of this matter, there is no evidence that Mr. Nkosi will not stand the trial. Now, Your Worship, let me take you to this issue of the joggers. The joggers that the state has indicated they are from Musina, Rudaport, and various police stations within this province and Limpopo province, Your Worship. And in the affidavit in support of this bail application, there's a contention, Your Worship, that was made by the applicant that he is involved in matters that emanate from Musina and within other Barasa police station, because there was a task team that was established by the President of the Republic of South Africa and also the National Commissioner and the suspended Deputy National Commissioner. And there was no evidence that was presented by the state to refute such, Your Worship. And my client maintains that he was in possession of these documents because he was involved in the investigation of these matters as stipulated in the affidavit in support of the bail application.
Right, advocate, I might have to stop you right there and carry on with the address and the list of clearance.
There's a court ruling.
Let's fix the issue of the next date. When is your next available date now? The soonest?
Monday, Your Worship.
You have no availability at all prior to the 20th of April?
None, Your Worship. Thank you.
Yes, defense, Monday the 20th?
Your Worship, this is the abuse of the processes of this court. As I've indicated to you, Your Worship, that the bail application is an agent application by its nature. Today is the 13th of April. This matter started from the 2nd of April, Your Worship. And they are, in their affidavit, but I will deal with it, Your Worship, what they say in their affidavit. This court cannot just rubber stamp the postponement that are sought by the litigants before it, Your Worship. As I've indicated, this application is agent, Your Worship. And to grant a postponement until a Monday, Your Worship, that is not in the interest of justice, and it does not speak to what Section 35 of the Constitution states, Your Worship, as far as the bail application is concerned.
I would have sympathized with you, advocate, if I didn't have the following problem. This morning, we had to wait for you until 10 o'clock. We lost 1 hour because of your non-availability. If you arrived early, we would be finalizing these proceedings right now. In the worst case scenario, we would have had to postpone, maybe for judgment, who knows. But we had to wait for 1 whole hour for you, advocate, unfortunately.
Your Worship, I don't want to go back and forth with you. That's not true, because when I came here, I left my bag. I was the first person to come to this court. So I don't want it to be out there that the court had to wait for me for 1 hour. I was the first person in this court, and I left the bag. And I also indicated that to my learned colleague when I arrived that I was here, but I just stepped outside to speak with my client.
We couldn't find you, but be that as it may, next time, because obviously we are not going to finalize today. Now I'm speaking to both the state as well as the defense. Let us not lose an hour unnecessarily. Let us use each and every minute fruitfully. It doesn't matter who came first, but let us meet in court exactly 9 o'clock. Let us start with the proceedings. In that fashion, we'll be able to finish. We are here now because of the hour that we lost in the morning. You are right, we shouldn't go back and forth, but as far as I know, I was told that the defense is not there, hence I had to wait until 10 o'clock for me to be able to start with the proceedings. Now let's deal with the issue of the date. She says she's only available on the 20th. We have objected. I have to give a ruling, obviously, on that. There is no other way. I cannot be unfair and postpone a case to a date when they are supposed to address me, but they will not be here to address the court. Therefore, I'm inclined to give them a postponement until the 20th. My question is, advocate, are you available on the 20th?
I don't know, Your Worship. Let me find out. Your Worship, the matter will be postponed to the 20th. I will say what to do on that day.
All right, thank you. Thank you. You confirm the 20th as Thursday?
I confirm the 20th, Your Worship.
Right, Mr. Nkosi, please stand up.
If I may tell my Your Worship before you postpone the matter.
Yes, you may approve.
Your Worship, there was an order that was made on Tuesday that he be placed in the hospital section. I request that the same order be made.
Why is the hospital wing?
Your Worship, the reason for the special hospital wing is that he is concerned that he might be poisoned while he is in prison. And in the side of hospital wing, there are measures to ensure that such does not happen. And that's the reason why the magistrate to postpone the matter on second, postpone the matter as such.
Thank you. What's your take on this?
Yes, when the matter was postponed at the last occasion, it was indicated that the accused has diabetes. Therefore, the state had no objection with him staying in the hospital section in order to get access to the medication. Although it was not mentioned now, that was...
Was it because of diabetes or was it because of a fear of being poisoned? What was it?
Those were all the reasons that were advanced before the court, Your Worship. That is diabetic as well. I forgot to mention that.
I don't see why a person must be kept in a hospital wing. I'll tell you my reasons now. The hospital wing is reserved for people who are admitted as patients. By merely saying that the person is diabetic, that does not justify being admitted in hospital. And also, my other concern is he says he's afraid of being poisoned. If he's afraid of being poisoned, whether he's hospital wing or general prison population, I don't see where that is stemming from. I'm not sure if that is the right order that my colleague made, and I'm not inclined to make such an order. Placement of a prisoner in a prison hospital wing is reserved for detainees who require medical treatment, observation, or nursing care. It is not designed for function as a form of protective custody in the absence of any medical necessity. And for me to say, because he's diabetic, now I'm saying that he must be admitted, that will be unfair to the prison authorities. They are mandated to make sure that everyone in their case taken care of and they are safe. They will exercise their discretion there to ensure his safety. I'm not going to make an order that he be kept in the hospital wing. They will make sure that he is taken care of, that he is safe, and I cannot find any reason, any substantial reason why I must say that he has to stay in the hospital wing. He will stay in the general population. They will ensure his safety, like they have to ensure the safety of each and every detainee in their custody. I am not going to micromanage the prison. and say somebody must go here or somebody must go there. They will assess the need, they will assess the possibility, and they will make their own decision. Right, your case is remanded until the 20th of April 2025 in this court. It is for us to continue with your formal bail application. You will be kept in custody until then. You may interpret, Ms. Kosana.
Icala lakho lifikisiwe uzobuya enkantolo ngomhla ka-28 April ilandela ngoMsombuluko okwamanje uzobuya ngasebenza.
Right, 20th of April, 8:30 in the morning, so that we can start at 9 o'clock.
Thank you.
Correct.
All right.